Getting quiet.
Good evening to everyone, but good evening to all of us. Call to order the State of Rhode Island Coastal Resources Management Council Planning and Procedure Subcommittee to order. Today is Tuesday, May 14, 2024. First matter on the agenda would be approval of the minutes of the previous meeting that was held on April 9, 2024. I know they've been disseminated. Any questions? If not, I'd entertain a motion to.
Looks fine to me. I move acceptance.
Motion has been made. Is there a second?
Second.
Motion made and seconded. Any discussion? All in favor, say aye. Anyone opposed? Motion carries. I also would ask that the record reflect the council members of the subcommittee that are present. First, formal matters, old business works in progress.
There are no old business nor works in progress, Mr. Chairman.
Next will be proposed programmatic revisions for review and action. Letter A, 2024-04-071, Quidnessett Country Club petition for change to map of water type classification for North Kingston, parentheses, north. And
I'll start, Mr. Chair, before
Director
I pass it over to Bruce. We received a petition to change the water type in front of, on the water, obviously, of the 14th hole, the Quidnessett Country Club, in response to an enforcement matter where the country club has installed riprap revetment without a permit. We issued enforcement on that. And one of the strategies that the country club would like to employ to address the enforcement is to petition us to change our water type designation, because as it stands right now, type 1 waters do not permit structural shoreline protection along those shorelines. So they're petitioning us to change it to type 2 waters. As Bruce will explain in a little more detail, what we have to do when we get a petition for rule change is act within 30 days as to whether or not to accept it or to proceed with rulemaking. We couldn't meet the 30 days from the time we got the petition to this meeting because the 30 days would have expired. So I asked the council for the Quidnessett Country Club if they could waive that statutory requirement. They did. That's in your packet of information here. But here we are. And we have one of two paths to follow tonight. Well, three, really. You can deny the petition right here and right now and we're done. We don't have to do anything more than that. Or we can proceed through rulemaking. Then there's two paths to go on rulemaking. The traditional one, which is where the council is in favor of proposing a change or changes to its regulations. And we go out and begin rulemaking. That's one you're all very familiar with. We've done that for many years, even under the new ORR scheme. However, petitions don't fit under that because we have not taken a position one way or the other on rulemaking, whether or not supported or not. So there's only really one other path to follow, and that's an advance notice of rulemaking. We've done this before with the cable corridor for Revolution Wind coming up the West Passage. We've advertised those that way. And as Bruce will explain now, I'll pass it over to Bruce. That really was the only avenue we had where this petition fit under the ORR process, because we have to go through ORR to do any sort of rulemaking whatsoever. So I'll take it from there, Bruce.
Thank you. Yeah, as Director Willis mentioned, this is a petition we received. It's a petition for promulgation of rules. It's pursuant to Rhode Island General Laws 4235-6 and CRMC Management Procedures Section 1.4.9. It was submitted to CRMC on April 12th. We did receive a continuance and we scheduled it at the first regularly scheduled Planning and Procedures Committee meeting. As Director Willis mentioned, we have 3 different options. One is to deny the petition in a record and state the reasons for denial. 2 is to initiate regular rulemaking. And 3 is to direct staff to initiate rulemaking, utilizing the advance notice to propose rulemaking. Because this is a petition, normally when we bring, policies and regulations to planning and procedures, it's usually gone through an internal process by staff where we've reached out to stakeholders, we've done regulatory analysis, but in this case, because it's a petition, that hasn't happened because it's not a staff action. So those are the 3 options for consideration this evening.
Was there any other way to bring it in other than a petition? From the request? I went through this material and I got really mixed feelings on it because it's some type water. We don't have much. We want to make a change to type 2. And then it dawned on me, we did something very similar for over the Mount Hope Bridge there. They wanted to have some sailing, a dock extension, and the only way they could get it was to have type 2 water. We granted a little piece out in front so they could, build a dock and hold their, not yacht races, they were, sailboat races and stuff, if you remember.
But I do remember it was a little different scenario because we had permitted a dock facility for their aquaculture, research aquaculture in type 1 waters. And then over the years, the university kind of used it as their sailing operations.
Yes.
And so that was the reason they said, well, we already have a dock. We just need to accommodate sailing on it now.
I think the shellfishermen would got a little concerned or something, but yeah, they got that dock. And I was remembering that's the only example I remember of taking type 1 waters and turning them into type 2. And if we did that, how much land, how much water are we talking about? It doesn't, it sets a precedent.
Well, we haven't really looked into it, Mr. Gomez. We just,
okay. So you just need to.
yeah, in terms of staff, because we have to follow one of 2 paths, deny it outright or start rulemaking. This advance notice of rulemaking was the only one that fit under the ORR umbrella. It's the only one the state has. So they don't really have a model to follow or a template to follow for these petitions. They only have an advance notice where you're thinking about things or an actual rulemaking, and this one is not an actual rulemaking. So it just, again, it wasn't a neat fit, but it was the only one available to us.
If we wanted to proceed with.
And that's what the discussion would be tonight. Do you want to pursue the petition as an advanced notice of rulemaking or just say no?
Is this what they're trying to do is kind of a result from climate change and higher surf and stuff like that?
They have,
Are they losing waterfront?
they have backup material that'll be part of their argument, and we'll incorporate that. We'll try to understand what their argument is in our analysis of it as well.
I have 2 questions about that. When you say deny it, do you mean we as a subcommittee can deny it, or does it need to go to?
Well, it basically says the agency, so it would, I guess it would be a recommendation of the subcommittee to the full council.
And I know that when it comes internally from us, there's a process for public outreach. Was that done? Because I see this affects, abutting property owners also. So
That's, so the advance notice of proposed rulemaking would go out to public notice. We'd have a public comment period, and that's actually one of the reasons why agencies use that, is we get a lot of input, recommendations from stakeholders and the public. So that would be one of the reasons to also take that path, is to get as much public comment as possible.
I think it would have been easier to entertain a petition for change if they hadn't already built the revetment. And I think to kind of, we should see how the enforcement action plays out before we entertain any petitions to change anything.
Well, I think this was one of the ideas the country club had to address the enforcement action.
Right.
And there's no other option for some type of variance, rather than make such a big type of change to the type of waters, there's no other.
In type 1 waters, structural shoreline protection is not allowed.
It really is a matter of whether we really want to try to put out a signal on type 1 waters and hold those as precious to the state of Rhode Island, if you will. There's a small percentage of the state of the water is type 1.
70% of the water types in Rhode Island, the shoreline types are type 1 and 2.
Yeah.
So I don't have a breakdown between 1 and 2. But yeah,
To
they're
me,
low intensity.
again, as I went through it, I'm saying, damn, and then I remembered that we have done it in the past. So, but I don't know the ramification of if we deny it. Is it something that is critical to their operation?
Do you mean if P&P recommends not moving forward and then it goes?
If we just said deny it,
Yeah.
is there, are they gonna fall off the end of the earth over there?
Well, then it becomes, the enforcement path is a lot more clear. They go for order, restoration, et cetera.
Yeah. Why didn't they follow that? Time, were they worried about time?
I think all that'll come out in the analysis.
So that would be the remedy. There would be some option for them to move forward if we didn't consider the change. So what
No,
would be the
it'd be
option for the country club to fix this?
Well, they'd have to work through the enforcement staff and without projecting or without assuming or without broadcasting what enforcement should or shouldn't do, they would work to rectify this situation. And in all likelihood, well, I'll just leave it there.
But there is a remedy. that could-
I don't know if there's a remedy. The remedy on our end might be in order to restore it.
Right, and to restore, so they'd have to undo
Right.
the signature hole in the golf course. I mean, the ramifications are huge, and I'm not saying what they did was right or wrong, but I'm of the opinion, let's give them an opportunity to come in and present their case. I mean, the extent that this,
As opposed to making a decision on anything tonight.
well,
No,
my opinion,
I'm
I
just
mean,
trying to
as opposed to
clarify.
deny it at our level
That's-
and then send the denial to the full council. I mean, my familiarity with it from reading the materials, in my opinion, warrants at least allowing them an opportunity to come in, do the rulemaking, let the public be heard, give them a chance at the process, as opposed to summarily denying it
So we
here.
could table this and,
We're not table it, vote, I think, and then I guess.
no,
we
but
have
to get to where you want to get to, invite them in.
No. To get to where I want is we vote tonight to allow them to do the advanced notice of rulemaking.
Right,
That gets the ball rolling.
all right.
Yeah, Mr. Chair, just to add, and I think Jeff's already mentioned this, that's under the rule. We have 30 days from the petition, so it'd have to be one or the other. And like you're saying,
I don't know if you guys can support that, but that's where I'm at.
I'll support your recommendation. My head wants to go tonight, but I'll support, giving them I guess a bite at the apple. If, I'm not sure exactly how you want.
How would this
Where'd you
fit
amend it?
into the enforcement action?
Well, actually, depending on how this shakes out, if this results in a water type change to type 2, then the enforcement path is a lot different than if this doesn't result in a change to the water type.
But you have an enforcement action now, right?
Right.
Is that going to be on hold until this is resolved, or do you need to move ahead? Is it going to go to like an administrative hearing officer?
We haven't issued a fine. Correct. We have not issued a fine on this. We just issued an NOV on it, I believe.
They would probably stay it, if I'm not mistaken, right? Would stay it, let them do this and then,
I think that would be the country club's argument.
yeah, and then to your point, as you said, depending what happens here, If it's granted, well, the enforcement's a little bit different because you deal with what they did when they did it.
Isn't there an emergency kind of request to do work on if there was like an emergency action along the golf course? Put some kind of, not something less than stone to kind of hold it.
There really wasn't an emergency situation.
That kind of makes
Yeah, but
the violation worse.
well, I don't want to get into the violation nor the analysis. I think I could answer your question, but I don't think it's appropriate to,
Okay.
here.
So you've issued a cease and desist, like,
Yes.
yes,
Mhm.
and has taken a look at it a couple
Our
of times.
enforcement staff have sat down and met with the country club at least once, if I think twice actually, on how to address the situation, how to get it restored, et cetera. And this was a response of the country club, a petition to change the water type.
Do you see this as a precedent?
Yeah, yeah.
I tell everyone, and there's no one here, we don't set precedent, we look at every case individually. Because that's usually what the people in the back are saying, but it's gonna set a precedent here, it's gonna set a precedent with this, and to me, we look at every case on its merits. It's my standard response.
Do they have an alternative other than the stone revetment? Can they use like a soft type of barrier that we've used in other shorelines?
Well, I don't know, and I'll ask Mark this. I don't know how appropriate it is to discuss issues that have come up on that shoreline in the past that we have dealt with. Because I think that would be part of the,
Yeah, I wouldn't want to get into
okay.
that.
I would say run to answer that, it not with particulars, I think that will come out in hearings on the advanced rulemaking, am I correct? What if they're making a pitch for this, what they're asking for? I'm sure people are gonna talk about other things, like do you have other alternatives and to Ron's point, so.
It may, you're absolutely right. So it may come out, as long as it comes out and we've tried certain things, they haven't worked, or we've done this, we've done that. But if it's in context of the violations, that can be difficult because we don't want to appear to be influencing any potential hearing that might occur on enforcement.
Okay,
So we could give them the opportunity for rulemaking. The answer could still be no at the end. But of the council that the petition would be denied, or the water body wouldn't change, and then they'd have to deal with the consequences of that.
Yes.
But this gives them the opportunity to come in front and make the case.
I believe so, correct,
Yes.
and it would go to the full council, correct?
On your recommendation, I could, yes, it could go to
What I'm saying, if we made a vote to
either way.
do the advance notice of rulemaking,
Yes.
does it stay with us, or by virtue of that, does it go to the full council?
My understanding is that it would stay here until until the subcommittee makes a recommend or takes a position on it, whether it's going to move forward or not.
But it does go to the full council.
Yes, for the
But-
recommendation.
But what I would do, whatever decision's made here now, at the 6 o'clock meeting in front of the full council, I would just report out that P&P did the X, did
Yes.
whatever.
Yeah.
That's all I would do.
Yes.
We're not seeking anything additional at the full council. We're just
No.
reporting out because the process will be down here.
Absolutely. So the process will be down here until it's, until it's firmed up on whether or not it's going to be a recommendation for approval or denial.
Okay,
But ultimately, the subcommittee recommends to the council, but everything, all the, all the other stuff, the nitty gritty stuff's going to stay here.
okay.
They knew this was happening tonight. I expect they did.
We advertised in accordance with the APA.
Stinks.
So, Mr. Chair, did you So do you think that it's possible that we could move for option 2, but before we send it to the full council, we have the applicant come in so that we can ask and get answers to some of these questions? Is that an option that we could do, or no, that has to be done before the full council?
I don't know that, so that's why I'm asking. I'll let council or Director Willis answer that if they know.
Because I'm curious about sort of the geometry of this, why they would decide on this, why would they include other people's property? So I'm just, I'm wondering if there would be sort of an intermediate option where we would have
We're not here.
the applicant here, so we could
Tonight,
ask some of these
They
questions.
knew
Or is
this.
that more appropriate before the full council?
I think that, that's something that they could come here and, they could have come here tonight and said what the whole petition's about, why they're going for it. And then it could be reiterated at the council. And this is an open public meeting, so.
Because I am concerned that they took this action and then their way to remedy it is to change all of our rules. So I think, it's a big step for us to take for something like this. And I think,
So just for context, process, I have discussed process with Country Club's council. And my comments to their council was that we're bringing it to PNP to explain the avenues we can take. We never really discussed attendance, to have those types of discussions at tonight's meeting. It was more of a process type conversation.
okay, if our choices are then to deny or to move it forward for advertising rulemaking, I would at least give them an opportunity to come in rather than just flat out deny it at this level. That's what I'm thinking.
Well, Don had indicated he's in favor of a motion to approve the avenue of advance notice of rulemaking.
I would second that.
Subject to correction, I guess, but so say that again, please. I got my hearing aids in, so that's not the problem.
Why is it that you,
No.
well, I'm just saying, as far as
Yeah,
yours,
reluctantly, I said I would support your position.
right, and Tricia said that she would second it.
Okay. Then I will leave my motion as is.
Okay, I know you said you'd make one, so I just, in formality, if you can make that motion.
I move that we address this issue with the advanced rulemaking that would be brought back to us. Oh, that would come back to people. Okay, that would come back to us at PNP to determine if we like the results of that, basically. Before moving forward. to the
Motion's been
full
made.
council.
Is there a second?
Second,
Motion made and seconded. I'll poll the subcommittee members, Mr. Gomez,
Aye.
Mr. Gagnon,
I reluctantly say aye.
Ms. Reynolds.
aye.
I vote aye.
She held a nose.
All right.
So, Mr. Chair, just before you conclude, what we will do as staff is we will take the petition, working with council to get language and materials to put in the advance notice and advertise it probably as early as next week and start that ball rolling. We'll do a 30-day public comment period, et cetera. And then staff will do its investigatory work and analysis and try to put all this together. And at a date in the future, probably sometime this summer, I don't know, I'm just thinking out loud, we bring back what we've accomplished with the recommendation to move forward. So that seems to me the process that we would follow.
Okay. Any questions of Mr. Willis on what he's explained? Any other business?
There is no other business.
New
Mr. Chair.
business,
No
staff
new
reports, entertain a motion to adjourn.
So moved.
Second.
Motion made and seconded, all in favor, say aye.
Aye.
Aye, anyone opposed, motion carries.
Oh, jeez. The only reason I come